Now I'm going to start polity, and what I'm going to do is focus on trying to revise the chapters that I mentioned earlier, which are fundamental rights, preamble, and if we have time, maybe some fundamental duties as well. But again, I think from the reaction that I have gotten to questions and how you've been answering, I think the focus I will try and retain a bit on questions as well, because no matter how much you revise the topics, if you're not able to crack the questions, then the purpose is defeated. And our purpose is not to master the syllabus, but to answer questions. So we're going to also ensure that there's enough focus on questions. But until then, I'll start with starting some revision of the basic concepts. And for polity especially, I would like it if all of you revise the sections and come. I'll mention, I'll try and structure it so I can mention which chapters we're planning to do. So I can collect questions also accordingly. And if you revise and come, it will be useful because in half an hour, you cannot revise that much polity anyway. Instead, if you do questions, then through questions, it will be much more useful. You'll be able to see how tricky the question can be, how they're asking questions, and it'll help you learn better. It'll help you revise better. Okay. So given that, let's start. Okay, so we'll start with preamble. So some important characteristics of preamble. First is that preamble was derived from the American Constitution. That it used it's a concept like basically the entire Indian Constitution has been called a bag of borrowings because different parts of Constitution have been derived from different constitutions from the world. So preamble has been derived from like American Constitution as a basis. Preamble also existed in Government of India Act 1919. In Government of India 1919, you can say that the Montague Declaration, like 1919 Act, if you recall from history, was called Montague-Chelmsford Act. Okay, so Montague Declaration has also been considered as some motivation or inspiration for the preamble. Another related concept and for preamble, and from where a lot of our preamble has been borrowed, is the objectives resolution. Nehru passed the objectives resolution, and a lot of the concepts that he said in the objectives resolution, even the wording that he used in objective resolution, became the basis for the preamble. Okay, there are two important cases with regards to the preamble that you need to remember. That first is Berubari Union case. Berubari Union case said that preamble is not part of the constitution. I'll wait. At least this detail you can write down if you don't remember. Berubari Union case. Berubari Union case said that preamble is not part of the constitution. But then in Keshavananda Bharati case, it said that preamble is a basic part, is a part of the constitution. Related to this, in Keshavananda Bharati case, what they also said is that preamble can be amended except for the basic features. Except basic features, preamble can be amended. And with respect to the preamble, a very important amendment is the 42nd Amendment Act. 42nd Amendment Act, 3 words were added to the preamble, which was socialist, secular, and integrity. Socialist, secular, and integrity, 3 words were added in the 42nd Amendment Act. There's a question on unable to remember judgments. I think one way to do it is just to write. Anytime you don't remember a judgment, just write it 1, 2 times, 2, 3 times, just like tell it to yourself, revise. That way you can remember. So those are all the important details that can be asked as questions. These are the details from preamble that can be asked as questions in prelims, in my opinion. Okay, and the last part is that preamble is not justiciable. Preamble is non-justiciable. Non-justiciable meaning it cannot be. It is not a restriction on the powers of the government, nor is it an entitlement. Preamble is not justiciable. You cannot go to court using preamble. Okay. So that is it with regards to preamble. Next, let's move to fundamental rights. Fundamental rights will take time. Okay. So fundamental rights again has been borrowed from American Constitution. The basis for fundamental rights is the Bill of Rights. Is the Bill of Rights of the US. Now there are some important differences between Bill of Rights and the Indian Constitution's fundamental rights. Okay, questions have been asked related to this, so just make a note of these points. First is that in Bill of Rights, the rights are absolute. First is that in Bill of Rights, the rights are absolute. Absolute meaning there are no restrictions on them. Okay. The right becomes the most important part. Okay. But in India, the rights are qualified. India, the rights are qualified, and the restrictions are mentioned in the Constitution itself. And the restrictions are mentioned in the Constitution itself. In India, the fundamental rights are qualified, and restrictions on fundamental rights are mentioned in the Constitution itself. In US also, there are some restrictions on fundamental rights, but those restrictions are not mentioned in the Constitution. In the US also, there are some restrictions on constitutional rights, on fundamental rights, but they are not mentioned in the Constitution, in the Bill of Rights. Okay. Instead, in the US, the restrictions evolved through a judicial process, and they are constantly evolving through judicial processes. Bill of Rights, the restrictions are evolving through a judicial process. They are not mentioned in the Constitution. They are not mentioned in the Constitution. Okay. And then let's look at some of the let's start looking at some of the rights and some of the details, some of the important details you need to remember for each right. Okay. So Article 12. Article 12 of the Constitution deals with the definition of what a state is. And in this, basically, everything is there. Union executive legislature, state level executive legislature, local authority, meaning panchayats, municipal and all of that, and PSUs, state agencies, all of them come under this definition of state. One important point to remember for definition of state is, when you are looking at agencies, meaning supposing government has given a contract even to a private player, but it is to carry out the operations of a state, then it comes under the definition of a state. So even private player can come under definition of state if it is working as an agency or instrument of the government. Okay. So even private players can come under definition of state. Next article is Article 13. In definition of state, the courts do not come. Courts do not come under definition of state. Fine. Next, Article 13. Article 13 basically allows for judicial review. It says that if there is any law which is inconsistent with fundamental rights, if there's any law which is inconsistent with fundamental rights, then they will no longer be considered, that part of the law will be struck down. If there's any law which is inconsistent with fundamental rights, it will be struck down by the laws, by the courts. What am I saying? Okay. So basically, to the extent that a law is inconsistent with fundamental rights, it will no longer be considered a law. There's a technical term for this, which is doctrine of eclipse. So there are two terms, doctrine of eclipse and doctrine of severability. Both are related to Article 13. Doctrine of eclipse and doctrine of severability. So doctrine of severability, what does it say? Doctrine of severability says, should I slow down? Should I say this part fast? Does everyone know what doctrine of severability is? Fine. Doctrine of severability comes under Article 13. It is an interpretation of Article 13. Doctrine of severability, what it says is that in case a law violates a fundamental right, in case there is a law which violates the fundamental right, the entire law will not be invalid. Only the provisions of the law which violate the fundamental right will be invalid. Okay, severability. Okay, in general, I will not go I will go slightly quickly in these revision sessions because we are not doing full polity. Like full polity, even it will take like 2 months, 2.5 months to cover. This is only a quick revision so that we can solve questions. The focus is on prelims and the focus is on solving prelims questions. So first doctrine is doctrine of severability. Doctrine of severability, what it says is that in case a law violates a fundamental right, the entire law will not become invalid. Only the specific provision of the law which violates the fundamental right will be struck down. Meaning, law will be struck down only partially, not the entire law. That is doctrine of severability. The second doctrine, which is enabled by Article 13, is doctrine of eclipse. I'll type that also out. Doctrine of eclipse. So, what doctrine of eclipse says is that if any law or act violates the fundamental rights, then the fundamental right shall eclipse the law. Okay? If supposing there was a law existing from 1935, doctrine of eclipse is basically to deal with the laws which existed prior to the enactment of the constitution. Okay, in India, when the British rule laws existed, British had lots of laws which were like curtailing freedom of speech, which were restrictions on press, restrictions on individuals, and so on, right? Okay. So doctrine of eclipse, goal of doctrine of eclipse is to deal with those laws. What doctrine of eclipse says is, supposing a law was in existence and existence from 1930s, 1920s, something, law was in existence. But now constitution has been passed in 1950. All the laws which are inconsistent with the fundamental right will be eclipsed. Okay. Laws which are inconsistent with the fundamental rights will be eclipsed. And the law can be enforced again if the restriction placed by fundamental rights is removed. Eclipse ante, eclipse means like solar eclipse is there, right? What happens in solar eclipse? The moon covers the sun and you cannot see the sun. Basically, in doctrine of eclipse, what they're saying is fundamental rights are like the moon. Fundamental rights will prevent all the previous laws which are not consistent with fundamental rights from being in action. Okay, all the old laws will be covered, will be shadowed by the fundamental rights. That is what doctrine of eclipse says. And if you want a law, supposing there's a law which is violating fundamental rights and it is not applicable currently, how do you make it applicable? You change the law or you change the fundamental right. In any of those scenarios, then the law will automatically again become applicable. So these both are arise, like these two doctrines get their powers from Article 13. Article 13, which also allows for judicial review, gives the powers for these two doctrines. So under Article 13, what all is considered to be a law? Permanent laws passed by Parliament, passed by legislature, ordinances, then delegated instruments. Delegated legislation meaning what the government passes. When government passes order, rule, bylaw, notification, regulation, all these will also be considered as a law. Finally, like customs, if there are any like customs or normal traditional usage of law, that will also be considered to be part of law. The Article 13 specifically says that constitutional amendment will not be considered as a law. Constitutional amendment will not be considered as a law. Another condition on Article 13, which is not specifically mentioned in the Constitution but is implied, is that personal law, personal religious law, is also not considered as a law. Under the definition of law, constitutional amendment and personal religious law These two things will not be considered as part of the definition of law. Constitutional amendment and personal religious law. These two do not come under the definition of law. Therefore, what is the implication of this? Supposing there is a religious practice in a religion, there is a religious practice, okay, that cannot be struck down as being unconstitutional because it is not considered as part of the law, except under certain restrictions. Those also we'll discuss. Okay, those restrictions are there under Article 25. You're aware that public morality, decency, order, all of those conditions are also there. But personal religious law does not come under the definition of. However, even though personal religious law and constitutional amendment law are not part of definition of law, in case there is a statement saying are they subject to judicial review or no, answer is yes, they are subject to judicial review. Okay, and that also is part of Keshav Nanda Bharati case in case of constitutional amendment. Then just another fact to note down. Again, questions are generally asked on this. What are the 5 fundamental rights which are only available to citizens and not available to foreigners? Okay, there are 5 fundamental rights which are only available to citizens and not available to foreigners. You should remember that, which are 15, 16, 19, 29, 30. 15, 16, 19, 29, 30. Okay, these are not available to foreigners, only available to citizens. So let's come to right to equality first. Right to equality first is Article 14. Article 14 says that like equality before law and equal protection of laws will be granted. Equality before law, British concept. Equal protection of law, American concept. Okay, equality before law emphasizes equality. Equal protection of law emphasizes equity. Okay, and like Article 14 not only protects individuals but also protects companies, corporations. Article 14 explicitly forbids class legislation, meaning you cannot make a legislation which looks at people as a certain class, as either rich or poor. Reasonable classification of people is allowed. Okay, like so for instance, when you say educationally backward sections, economically backward sections, such classification is allowed, but only on reasonable basis. You cannot classify people as a certain class. That's what, like, basically this term is there, this line is there in the constitution, so you need to know. In case a question comes on it, you need to be able to say yes, that constitution prohibits class legislations. Okay, and any reasonable classification like educationally backward, fine, needs to be based on an intelligible differential. It should not be arbitrary. It should not be arbitrary. These are just lines which are there in the constitution which have been asked as questions in the past. So I'm just revising that for you. Okay, rule of law, A.V. Dicey has given rule of law. 3 statements are there for rule of law. Absence of arbitrary power, equality before law, meaning everyone will be subjected to law equally, and that individuals are the source of all rights. This is third, individuals are source of all rights is not there in our constitution. It is only there in British constitution. For us, constitution is the source of individual rights. That is one important difference to remember. Again, questions have been asked on this fact. There are certain privileges which are given to president and governor. Okay, first is that like in their duty, when presidents and governors are performing their duty, they are not answerable to any court. Court cannot question the president or governor. Second, criminal proceedings cannot be instituted against the president, and only civilian proceedings can be instituted. That also only if 2-month notice is given for civilian. And arrest, obviously arrest is not possible for president or governor. Okay, next, Article 15. Article 15 talks about prohibition of discrimination. And prohibition of discrimination is on 5 grounds. These 5 grounds also you need to mug up and remember. Okay, these are religion, race, caste, sex, place of birth. And relating to this, Article 15 prohibits both discrimination by individuals as well as the state. Okay. It's not only that the state will not discriminate, even individuals cannot discriminate. Then you have Article 16. Article 16 relates to employment, relates to equality of opportunity in public employment. So, in a sense, like job reservations also come under Article 16. Article 16, there are 6 grounds. There are 6 grounds to remember, which are religion, race, caste, descent, caste, sex, descent, and place of birth. And place of birth or residence. So basically 6 grounds are there. In Article 15, there were 5 grounds. Article 16, there are 6 grounds. And the important exception here is residence. Because Parliament can prescribe residence as a condition to reduce the employment opportunities. So in AP, such a law exists. And in AP, that law started to exist because of this thing, that those rules were there, no, Mulki rules. Due to Mulki rules, this AP residence criteria was provided. And another exception to public employment is in case it is relating to a particular religious denomination. If there is a religious denomination, if your employment is to a particular religious institution, in that you can define religion as a criteria. Next, Article 17. Article 17 talks about untouchability. Untouchability, if anyone practices, can be punished. There are some important facts to remember here for prelims. One is that Article 17 is also available against private individuals. Even a private individual cannot practice untouchability. Second important fact is that if someone is convicted of untouchability, then he is disqualified from contesting elections. Okay, it's an important exception. You cannot contest elections if you practice untouchability. Article 18 is abolition of titles. Abolition of titles, there are 4 criteria, all of which have been asked as questions before. That there are no military there are no titles except for military titles in India. Citizen of India cannot accept a title from a foreign country. Foreigner who is working in India as a state employee or as a contracted state agent of the state, he also cannot accept title from other countries without the consent and permission of the Indian government. And citizens and foreigners cannot accept gifts or money or any from foreign governments without the permission of the Indian government. Within this, an important case is that what ones were there? These prizes, these Padma Bhushan, Padma Vibhushan, these Padma awards. Okay, these cannot be these are allowed. That there was a case saying that does this count as a title or no? And then they said Padma awards do not count as titles. Even academic titles are also an exception. Academic titles do not count as titles. And Padma awards are allowed, but you should not use Padma awards as prefix or suffix. You should not use Padma award as Padma Shri X person, is what the courts have said. Then you have Article 19. Article 19 is right to freedom. So in this you have freedom of speech, assembly, of forming organizations, right to movement, right to reside and settle, and right to practice any profession. These 6 rights are only against states, against the governments. This is not available against private practices, private individuals. And these are only available to citizens and not to foreigners, and also not to legal persons and legal companies. So companies do not have this right. Companies do not have the right to freedom of speech. Only individuals and citizens have this right. That's an important point. For all right to freedom, you should remember that right to strike is not a fundamental right. Constantly this is asked. Right to freedom is not a fundamental right. So basically, I'm sure the right itself you're all aware. The tricky part is what are the reasonable restrictions. Each each right to freedom has some reasonable restrictions. First is speech. Speech has 8 grounds of restriction. Right to freedom of speech has 8 grounds of restriction. Sovereignty, security of state, friendly relations with other countries, public order, morality, contempt of court, defamation, incitement to offense. 8 grounds. All 8 grounds you have to mug up. Like there's no choice. 8 grounds you have to know by heart. Right to freedom of assembly. It is only allowed on public land. Okay, you cannot demonstrate on private land, private property. Only public land, maidans, those kinds of areas you can assemble. Right to freedom of assembly has two grounds of restriction: sovereignty and public order. Sovereignty and public order are the restrictions on right to freedom of assembly. When you see in these newspaper pieces, newspaper articles about traffic regulation, traffic being affected, if traffic is affected, is that enough of a grounds to restrict right to freedom of assembly? Answer is yes. Okay. And traffic and public inconvenience will come under public order. We said two restrictions are sovereignty and public order. Inconvenience to public will come under public order. Association. In freedom of association, individuals have right to start an organization, continue an organization, as well as close an organization. All three. Within this, again, an important point is that there is no right to obtain recognition. You may form your own organization, but there is no compulsion on the government to recognize your organization. Right to freedom of movement has two restrictions: interest of public and tribal areas. So for instance, if you're restricting movement of sex workers or prostitutes, that will come under interests of public. Then rights of residents. Residents also has same restrictions. Then right to freedom of profession. Right to freedom of professions also has some very important points which have been asked as questions. First is that state can prescribe qualifications. What qualifications the individuals needs for a particular profession. State is allowed explicitly under the constitution to have a monopoly. To have a monopoly and restrict people from practicing certain professions. Article 20 is related to conviction for certain offenses. In this, there are 3 provisions which are mentioned directly in the Constitution. One is no ex post facto law, meaning you cannot be punished if in case a law did not exist at the time of the committing of the crime. However, this is only applicable for criminal acts, not for civil acts. That is the important restriction. Ex post facto law, important restriction is it is only for criminal acts, not for civil acts. Then there is double jeopardy, meaning no person can be punished for a crime twice. However, this is only for judicial punishment. Administrative punishment through departmental proceedings can happen. And third is no self-incrimination, meaning you cannot be forced to testify against yourself. But again, restriction on this is that you can be required to submit DNA, to submit documentary evidence, to present yourself for examination, and so on. Article 21. Article 21 is right to life. Right to life. There's an important case, which is Maneka Gandhi case. Maneka Gandhi case, extremely important for right to life. What Maneka Gandhi case said is it brought out 2 differences. Maneka Gandhi case brought out 2 differences. First is it changed the definition of procedure established by law to due process of law. It allowed for a much wider interpretation of the term liberty. So Maneka Gandhi case is known for 2 things. First is procedure established by law was changed to due process of law. Second, it allowed for wide interpretation of what is liberty. So important fact is that currently Constitution still has written procedure established by law. Currently, Constitution still says procedure established by law, but the interpretation is due process of law. Okay, just remember that distinction. Then this basically under Article 21, there are lots of important rights which have been conferred by expansion, by interpretation of Article 21. You need to go through that list because question has been asked on this in the past. Last year or last to last year, on the basis of the Hadia case, I think right to choose one's partner comes under which article was a part of prelims, and answer is Article 21. Then you have Article 21A. Article 21A is right to education. Right to education, and it was established by 86th Constitutional Amendment Act. 86th Constitutional Amendment Act is very important. You need to remember which of the which in what all there were amendments due to 86th Amendment Act. 86th Amendment Act changed fundamental rights, fundamental duties, and DPSP. In all three, you need to know the specific change that it brought about. In fundamental rights, the change was that till 14 years of age, education is a guaranteed fundamental right. In DPSP, the change was that state will make efforts for early childhood education for 0 to 6 years of age. And in fundamental duties, the change was that as citizens, you need to educate children and provide for opportunity for children to get educated from 6 to 14 years of age. Article 8, this 86th Constitutional Amendment Act, three amendments in fundamental rights, fundamental duties, and in DPSP. All three you need to remember. Okay. Article 22 we'll do again tomorrow. Now we'll do some questions. I don't want to have any days when we're not doing any questions, because I feel that all of these are areas that you've already covered. Like I might be repeating things. The only way this session will be very useful to you is if you can practice a lot of questions and start getting questions right. If you answer quickly, we can keep doing more questions. It's an easy question. Okay, 10-15 seconds more, because it's a very easy question. So answer for this is B. B for Bombay. A lot of you have gotten it right. And just so I can check if you remember from our discussion, what is option D? Option D, we discussed the term today. Option D, what is the term for it? So option D is doctrine of severability. Doctrine of severability, was it done for you before, or is this the first time? And keep attempting. It's okay to get it wrong, but keep attempting, keep trying. So answer for the previous question is C. C for Chennai. Now, why is it C? Before I do that, like there are some doubts about doctrine of proportionality, so I'll explain that also. Doctrine of proportionality, what it basically says is that the outcome you are looking to achieve and the means you use to achieve it both need to be proportional. So supposing I'm making a law for ensuring cleanliness of the streets. Okay, then the law I make and the outcome need to be in proportion. I cannot say that because my streets need to be clean, any animals on the road or any people sleeping on footpaths all need to be taken away and jailed, right? Because that is not proportional. Okay, so doctrine of proportionality says that outcome. Doctrine of proportionality basically has become very important in light of right to privacy judgment. Okay, in Puttaswamy case, what it said is that if any law which is trying to infringe upon privacy of the individual, okay, then the object for which you are infringing on privacy and the means need to be in proportion. So for example, if you are using Aadhaar data to ensure that welfare is met, that is a good use of Aadhaar and it is allowed, okay, under doctrine of proportionality. But in case you're using data of individuals to spy on them, that is not proportional. So that is doctrine of proportionality. To come to this answer, there is a very, very important distinction in India, which is that individuals who are prisoners are not allowed to vote. Okay. In India, very important fact, individual prisoners are not allowed to vote. In fact, under trials, okay, if you're in under trial meaning you have not been convicted yet, you have not been found guilty yet, but you are currently in police custody. Even then, you are not allowed to vote. Even under trials in India are not allowed to vote. Under trials can contest elections, but they are not allowed to vote. Okay. Related to this, there's one more fact, and that is the basis of the next question I'm posting. 10 seconds more. Let's step it up. Let's do it quickly so we can do multiple questions. Okay. So answer for this question is B. B for Bombay. Answer for this question is B. B for Bombay. And what are the important details you need to remember here? First, related to the previous fact I was telling you. Individuals who are prisoners are not allowed to vote. But if you are a prisoner under preventive detention, you are allowed to vote. Okay. And only by postal ballot. You are allowed to vote and only by postal ballot. Okay. Then I'll just give you the list of all the people who are allowed to vote by postal ballot. Just remember it. Members of armed forces, obviously, because you're serving outside. Members of the government who are serving in posted outside India or outside the post of their residence, even they are allowed to vote by postal ballot. Then you have special voters who are President of India, Vice President of India, governors, cabinet ministers, Speaker of House, government officers on poll duty. They are all allowed to vote by postal ballot. For senior citizens, those above the age of 65, they are allowed to vote by postal ballot, not 60, above 65. And recently, government has also said that voters who test positive for COVID-19, even they are allowed to vote by postal ballot. Okay, so you have these members of armed forces, then like members of civil services posted outside India, then President of India, Vice President of India, governors, ministers, Speaker of House, officers on poll duty, and citizens above 65 are all allowed to vote by postal ballot. It is not 80 years of age; it is 65, and the Conduct of Election Rules 1961 has been amended for it. Now, importantly, you're supposed to know this. Like generally, you're supposed to know this because it has been covered a lot in the news, especially sedition. But even if you don't know, you should be able to eliminate options. In this question especially, I want you all to try and focus on trying to eliminate options. If you know the fact, you'll mark it instantly. But if you do not know the fact, try and eliminate options to arrive at the right answer. So I'm closing this early also because we did sedition as a topic when we're doing current affairs. And the way you need to eliminate is you need to have an idea of the other three cases. Answer is A, Kedarnath case. The other cases are all there in the fundamental rights chapter. If you had read fundamental rights chapter, you would have been able to answer them. So Keshav Nanda Bharati case 1973 basically said that basic structure doctrine was established. That any amendment to fundamental rights should not run counter to basic structure. What did Champakam Dorayarajan case say? It said that if there is a conflict between fundamental rights and DPSP, then fundamental rights will prevail. Golaknath case said that fundamental rights cannot be amended. Fundamental rights are absolute and are supreme. So if you know these three relating to fundamental rights, then you can eliminate these three and answer A. And also generally, if you just know that that answer A relates to sedition, then you know how to deal with it. This we just discussed. This question we just discussed, which are available against private individuals. Okay, this most of you have gotten it right. Answer is D. D for Delhi. Now you know that option A and B, we one and two we already discussed that that it is available against private individuals. Option D is this right to life is also available. Right to life also, like other individuals, private this companies and private individuals cannot exploit someone and cannot deprive someone of right to life. It's also very logical, but fact based, so I can understand why some people have gotten it wrong. But all three, and these three are the important ones: Article 17, Article 15(2), and Article 21. These three are the important ones which are available against private individuals. This is also very easily guessable. So try. Okay, let's 5 seconds. I'll close it. I'll give the last answer. C. Answer C for this question. And how do you arrive at C? You know that matters related to pension and gratuity, you have specialized courts for this. You have specialized tribunals, civil services tribunals. Then you have this administrative tribunals, CAT, Central Administrative Tribunal, State Administrative Tribunal. They are the ones who are responsible for dealing with pensions and gratuity. And so, the minute you can eliminate that option, only remaining option is C. Let's do last. I'll give let's do a question from DPSP. Easy question. Go on, easy question. Like you should answer this immediately. What I want you to understand from this question is even a term that you've heard 100 times, they'll find a way to make the language confusing. You need to read it very carefully, very slowly, because this kind of question, even if you don't know, you'll be tempted to attempt. Why? Uniform Civil Code, everyone has heard, everyone knows broadly what is Uniform Civil Code. But this kind of question, you need to attempt very carefully. Attempt very carefully and think about the answer before you attempt. And from what I can see, all of you have gotten, most of you, around 60% of you have all gotten confused in the options. These kinds of questions, read the options very carefully. Read the options very carefully. Okay, let's close it. Answer is B. B for Bombay. And I can see lots of you have answered C, lots of you have answered D. And I can understand what is the source of that confusion. So let's break down how to arrive at the answer B. We all know what Uniform Civil Code is. Uniform Civil Code, what does it aim to do? It says that personal law, that you have right now you have different laws, religious laws relating to marriage, relating to inheritance, relating to divorce. Like Muslim divorce laws are different from Hindu divorce laws. This Hindu undivided family, that concept exists for Hindus but does not exist for other religions. So like this, there are various laws which are religion specific. Okay. So what does Uniform Civil Code aim to do? That for civilian aspects, some certain civilian matters, to make the laws uniform. Okay. So which is why answer for it is B. How do you eliminate C and D and arrive at B? Because A you all know is wrong. It envisages uniformity in law of states with respect to practice of religion in countries. Okay. This does not aim for uniformity of law of states. We know that. It aims for uniformity between religions, for religion. So D is wrong. C, it aims for common set of laws for civil administration. Kind of hinting at B, but not exactly B. Because it is not for civil administration, it is for like civil practices, like secular practice, like for marriage, for divorce. It is related to stuff like that. It is not related to administration. Because there is no active administration of the religion happening here. Administration of religion would be what? It would be related to religious practices. It would be related to how you profess your religion. It would be related to like administration of the institutions, religious institutions. Gani, lekpote, you have these religious educational institutions, but it is not relating to that. It is related to personal law. So one law applicable for religious communities, not applicable for states, not applicable for administration. It is applicable for religious communities, which is why answer is B. But which is why like it will uh, these options will make it very confusing for you, and which is why you need to keep practicing questions, and we'll keep practicing questions. Even areas that you know well, they will try and confuse you to make you make a mistake. Okay. So for tomorrow, try and read the chapters and sections relating to this thing to Supreme Court, and we'll try and include questions from that as well. But tomorrow, my focus will be on trying to complete fundamental rights and fundamental duties.